Right, good morning. We are on the record in the 53rd Circuit Court for the County of Sheboygan. We are providing public access both in the courtroom and also online. We're here today on a short docket. We have first up, People v. Ralph Page, file 24-6875FH, continued from yesterday's docket. Counsel, you want to place your appearances on there?
Anthony Juliet on behalf of people.
Brian Clean appearing by and with Ralph Page, seated at council table to my right.
All right, and Mr. Clan, you just substituted in on the case. We're here today for a docket call. I imagine you need it set for further docket call. Right?
Yes, Your Honor. Thank you for, we had a brief discussion with the court and chambers, kind of discussed where we were. There is a lot of digital media. There's a lot of associated documents I haven't received yet. I did have some cursory discussions with Mr. Juliet today, but I asked the court to do us favorably consider reinstating Mr. Page's bond. We have some evaluations to go through, but Mr. Page was, and I'll tell him on the record, that the expectation is that he does not go to the next door neighbor's property for any reason. Is that fair, Mr. Page?
Yes, sir.
Okay, so you will not go onto the neighbor's property for any reason, correct?
Right. Yes, sir.
You're open to back in this situation, correct?
Right.
Okay. I would ask the court to consider that based on the totality of the circumstances and the fact that we are actively working to resolve the entire matter.
Would docket call and a status conference on the pending bond violation work on August 12th at 1 o'clock?
No, sure, of course.
Mr. Julia, any objection to that adjournment
No, Your Honor.
and people's position with regard to reinstatement bond?
I have no objection to reinstating bond with the same conditions.
All right, well, Mr. Page, that's great that, you're promising your lawyer not to go over there. Previously, a judge ordered you not to go over there and you did. So your promise to your lawyer means, not a lot to me because you've already violated a court order going over there. And it was not my hope in this case to have you end up in jail over these situations. But when you violate those core conditions of your bond, that's what courts are going to do. I think I've gotten some information from the jail about your age and some medical conditions, and they have a concern about you being there. So based upon that and what your lawyer and the prosecutor placed on the record, I'm going to reinstate your bond with the same conditions. But I hope I've proven to you one thing. If you violate it, I'll send you back to jail, and it won't bother me at all that the jail doesn't want you there. If you violate it again, you'll sit in jail for the rest of the case, and I won't reinstate it. Are we clear on that? You clear on that, Mr. Page?
Yes, sir.
All right. All right. I'll see you on August 12th at 1 p.m.
Thank you, Your Honor.
Thank you, sir.
So we also have a bench trial scheduled today on People v. Jacob Kiefer. Yeah. And I did meet with counsel in chambers, and it appears that we might have a resolution of this case that would remove the need for a bench trial. Is that correct?
That's correct. Yes, Your Honor. I gotta have him sign it. Right. So. Contest. Attempted kill. Attempted kill two. Okay. All those attempts. All right. We're gonna just sign it there. I was pain with your hand shackles.
Right. We should check.
Yeah. of this real quick. If you have no sense before, this your county vice versa, explain to you the very important rights that you're giving up by entering a plea today. Okay. So whatever you can say, you're not going to have a jury trial, you're going to all the rights associated with the jury trial, including the right to remain silent and having your silence not used against you. Briefly over to my client, as well as the signed plea agreement indicating a no contest plea to the counts containing the amended felony information of attempted B&E with a motor vehicle property more than $1,000 for less than $20,000, attempted count 2, same charge, larceny, and count 3 misdemeanor. I would acknowledge receipt of the amended felony information, the second amended felony information, waive reading of that to the record. We're ready to proceed with plea taking.
All right, Mr. Gauthier, if you please stand as best you can, raise your right hand for me. Just swear to tell the truth, the whole truth, and nothing but the truth, so help you God.
Yes, I do.
All right, Mr. Gauthier, and Mr. Clean, I'm sorry, the reason for no contest plea is that civil liability.
There is a potential for civil liability arising out of the transaction.
And Mr. Juliet, the people consent to that form of plea.
Yes, sure.
So, Mr. Gauthier, in no contest plea, I won't ask you about what happened. I'll review, and you can sit down if you will. I'll review this affidavit of probable cause, joint exhibit 1 for what happened. But I'll ask you a lot of questions just to confirm that you understand what rights you're waiving and what's going on. So my first question to you is, do you understand that a no contest plea, although it doesn't establish civil liability, it establishes criminal liability just like a guilty plea does? And so you'll be convicted of the offenses and I would have the authority or jurisdiction to sentence you. You understand that?
Yes, I do.
Okay. So for that reason, you're waiving a lot of constitutional and other rights that you have when you enter that plea. So I want you to listen carefully. If you have any questions, go ahead and ask me. If you need more time with Mr. Clayton, you just say so at any time. I have to advise you of the maximum penalty that you could face for the charges that you'd be pleading to. In the second amended information, count 1 is attempted breaking and entering a motor vehicle to steal for $1,000. And count 2 is attempted larceny over $1,000. Both of those crimes are a felony punishable by a maximum of 5 years in prison. Do you understand that maximum penalty, sir?
Yes, I do.
You're not on probation or parole anywhere?
No, I'm not.
Were you on bond for any other felony case at the time of this incident?
No, I was not.
All right, and did you read and understand the rights listed on the advice of rights form?
Yes, I do.
And you signed that?
Yes, I do.
You understand that that lists several of the rights that you have that you'd be giving up by entering a plea?
Yes, I do.
And is that what you're choosing to do today?
Yes, I am.
So you'd already waived your right to a jury trial and we were scheduled for a bench trial today. You understand at any time you can say, I don't want to do the plea, we'll do the bench trial today. At any time before we start the trial, you can say, you know, I'd rather have a jury trial and I'd give you a jury trial. Do you understand that?
Yes, I do.
If I accept your plea, you're giving up any claim that it was caused by any threats or other inducements or promises that aren't placed on the record today. Do you understand that?
Yes, I do.
Also, when you plead no contest, you give up the right to appeal. And if you wanted to appeal, you'd have to seek permission by filing an application. The types of issues you could raise on an appeal by application are very limited, much more limited than if you were convicted, say, after the trial. Do you understand that?
Yes, I do.
The plea agreement provides in exchange for your plea to the amended counts, the prosecutor will dismiss count 3. Previously, the habitual offender has already been dismissed. Do you understand the terms of that plea agreement?
Yes, I do.
Has anybody promised you anything other than that?
No, Your Honor.
Has anybody threatened you to make you plea?
No, Your Honor.
Is doing so your own free choice?
Yes, it is.
Knowing all this, how do you wish to plead to the charge in count 1, attempted B&E and motor vehicle over $1,000? Guilty, not guilty, or no contest?
No contest.
How do you wish to plead to the charge in count 2, attempted larceny over $1,000? Guilty, not guilty, or no contest?
No contest.
Okay, and I have reviewed what's been marked as joint exhibit number 1. It does appear that it establishes a factual basis to the elements of both offenses and that they occurred in the venue and on the date alleged. Mr. Clayton, do you agree that a factual basis has been established?
I do believe that the affidavit in joint exhibit number 1 does contain facts sufficient for a reasonable trier of fact to conclude guilt. So I'm satisfied the court can rely on that and enter no contest plea.
And are you aware of any other promises, threats, or inducements?
I am not, in my opinion, the court's complied with MCR 6.302.
Okay, Mr. Juliet, do you agree on all three counts there?
I do as well.
All right, Mr. Kiefer, I find that your plea is knowingly, understandingly, and voluntarily made, that there is a sufficient basis in fact and law to believe that you're guilty of those offenses. So I'll accept your plea of no contest to amended counts 1 and 2. I'll schedule sentencing for August 12th at 1:10 in the afternoon and direct you to cooperate with a pre-sentence interview so they can write a report for me with recommendations about what the sentence would be. Just so we have, I guess, a clear record, there's no promise about a sentence, but we did discuss in chambers that it was my understanding based on these charges that the guidelines are going to score out such that it's not likely that I would be looking at a prison commitment. But you understand there's no binding sentence agreement that's been entered in this case?
Yes, I do.
Okay. All right. Anything else you want to place on the record, Mr. Klein?
No.
Mr. Juliet?
No.
Okay. We'll see you August 12th, Mr.